And the one thing that really struck me is that he says that he categorized the settlement as a win for his client because he says now that they settled, they can focus on this 47.1 claim. And this is why I think it's a mischaracterization, because
if you've been following the headlines, you've likely heard Michael Gottlieb, attorney for the plaintiff, claiming victory. But as the legal community takes a closer look, the win is starting to look a lot more like a strategic retreat. Recently, Michael Gottlieb appeared on the Town podcast with Matt Bellan to explain why his client, Lively, decided to drop her lawsuit against Wayfarer. Gottlieb's main talking point? This settlement is a massive win because it allows the legal team to finally focus on the 47.1 claim. On the surface, it sounds professional. It sounds focused. It sounds like a chess move. Anyone who has been tracking this case since the beginning knows there's a massive hole in that logic. If the goal was always to focus on this specific claim, why did it take months of grueling litigation and thousands of dollars in fees to get here? It's like saying you're moving into a tiny apartment because you want to focus on minimalism, ignoring the fact that you just got evicted from a mansion. In the legal world, most people understand the difference between a sword, an offensive claim where you sue someone for money, and a shield, a defense you use to protect yourself when someone sues you. The 47.1 claim is, by definition, a shield. It's a relatively new piece of legislation designed to protect defendants in defamation lawsuits, specifically those involving allegations of harassment. It says, if you sue me for defamation because I spoke out about harassment and I win, you have to pay my legal fees. Here's where the victory narrative starts to crumble. Lively wasn't just a defendant. She was the plaintiff who brought 15 original claims against Wayfarer. Over time, those 15 claims were whittled down to just 3. And then, in the settlement, those final 3 claims were dropped for exactly $0. By dropping her claims, Lively isn't advancing toward a win. She is simply retreating to a defensive position that she has occupied since September. The 47.1 motion has been fully briefed and sitting on a judge's desk for months. So, if the 47.1 motion was already there, why did they keep fighting the other claims for so long? Ask any trial lawyer how often a plaintiff walks away from a major lawsuit with nothing. No settlement check, no apology, no admission of guilt, and they'll tell you the same thing. It almost never happens. When you file a lawsuit, you are effectively telling the world, I have been wronged and I demand compensation. To go through the discovery phase, where your private emails, texts, and life are poked and prodded by opposing counsel, only to walk away empty-handed is a massive pill to swallow. In this case, the defense, Wayfarer, ended up exactly where they would have been if they had gone to trial and won. They don't have to pay Lively a cent. The only difference is they save themselves the humiliation of a public trial. Gottlieb is in a tough spot. As an attorney, his job is to frame the best possible narrative for his client. But at what point does framing a narrative become ignoring the scoreboard? If you're feeling a bit confused, don't worry. You're supposed to be. This entire strategy relies on the public not understanding how legal procedures actually work. One of the most shocking revelations in this legal saga is that there is virtually no legal precedent for a 47.1 fee award. The legal team is betting the farm on a law that hasn't been tested in this way before. It's like entering a high-stakes cooking competition and deciding to make a dish that has never been successfully cooked in human history. It might work, but telling everyone you've already won before the judges have even tasted it is, well, it's a choice. Most experienced attorneys are hesitant to guarantee a win on a standard breach of contract case, let alone a brand new legislative motion. Guaranteeing a win in this scenario isn't just bold, it borders on a malpractice risk. So, why the confidence? Why the podcast tour? Why the aggressive "we won" branding? By claiming victory now, they manage the public perception and keep the story of the lawsuit alive, even if the legal reality is much bleaker. But what does Wayfarer think about all of this? Are they crying into their coffee? Or are they laughing all the way to the bank? If we look at this through a purely financial lens, both sides have lost a staggering amount of money. Wayfarer has spent millions defending themselves against 15 different claims. Lively has spent a fortune, or her firm has, trying to prove those claims. However, Wayfarer has achieved the ultimate goal of any corporate defendant. The lawsuit is over. They no longer have to worry about a wild card jury awarding a massive payout. They don't have to worry about their executives being grilled on a witness stand. They have essentially paid for the privilege of making the problem go away. For Lively, the win might be more personal than legal. Perhaps the victory is simply that the fire is out. She doesn't have to testify. She doesn't have to live through a trial. In the world of mental health and personal peace, that is a win. But in the world of law, it's a technical knockout in favor of the defense. We have to call it what it is: strategic PR masking a legal loss. While both parties can now stop the bleeding of legal fees, let's not pretend that dropping a 15-claim lawsuit is the same thing as winning one. What do you think? Is it possible for a settlement to be a win if no money changes hands? Or is this just a case of an attorney doing his best to save face for a client who had no moves left? Sound off in the comments below.